For today's podcast, we're going to be going over the Article 3 on the Constitution. But first, I want to ask people to consider becoming a patron to my Patreon page. That's www.patreon.com/challengehistory. It goes from $1 all the way up to $100. Breaking at $10, $25, $50, $100 increments above the base $1. It shows a little bit of my story right here at the title, and there's an intro post right here that I put on February 23rd for those interested in just kind of getting the introduction and little base thank you letter down there for those who have considered donating. And to any of you willing to donate with it, I really appreciate it. It helps me. I'm currently on disability, as you'll learn in this. And I do have other things going on in my life that I have to take care of. And when it comes down to it, is I want to be able to become self-sufficient other than disability to make my own living. And I want to be able to produce a better podcast as well. So all money from that will go toward those costs. Later on down the road, it will go toward different types of contests and such for different items, but that's at a later time with it, when I can actually get some more people in that would become cost effective for me to do that. Now when it comes down to this with it, you're going to notice that I'm not going on in my run. I'm not going to go into Article 4, Article 6, and Article 7. I will go into Article 5. That is one of the things, but I'm not going to go into those ones. When it comes to Article 6, that goes into a little bit of a different thing of stating that's on Article 6 is basically that's all debts shall be valid against the United States, and that is going into the idea of that basically they'll be basically bound to the Constitution, and which is a big thing with it. But there shall be no religious test for the qualifications of office. That's referring to senators, representatives, and members of several state legislatures. And then Article 7 is basically going under the definition of the word the word 30, the word is tried, and then reiterating the word the and as well, and basically for unanimous consent, and then for ratification as well. So we're not going to go over those points with it. Article 4 tends to go over the idea of privilege and immunities for several states. New states submitted into the union. New states may be admitted into the union, but no state shall be formed or erected of any other states, nor any state formed with an injunction of two or more states or part of other states without the consent of legislatures of the states concerned, as well as Congress. And then the United States shall guarantee every state party union form of the government shall protect each of them against invasion and on application of the legislature or the executive when the legislature cannot be convened against domestic violence. So we don't really we're not going to go over those points. But because they're not really you'll tend to find other groups tend to go over those. When it comes over to a lot of the things on Article 6, you're going to find a lot of people like JBS tends to do a lot of good work on Article 6. Article 7 is, you'll find many different other groups that will go over things like Article 7 and Article 4. That'll just go over the general basic history of it, so there's no real point. What we're going over here is to explain more of the actual role and the constitutional duties thereof, and why we get people acting out of their actual constitutional duties. That's the sole purpose that we're going after here with this actual series. And we go from section to section. The first one says, the judicial power of the United States shall be vested in the Supreme Court and other inferior courts, as the Congress may from time to time ordain and establish. The judges both in the Supreme and inferior court shall hold their offices during good behavior, and shall at times stated receive for their services a compensation which shall not be diminished to their time of continuance in office. Basically establishing the courts and establishing their compensation, and that they cannot have that compensation diminished unless they give just a reason for doing so. Judicial power shall extend in all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made or which shall be made under the authority, to all cases affecting ambassadors or public ministers and councils, to all cases of admiralty and maritime jurisdiction, to all controversies which the United States shall be a party, to all controversies between two or more states, between a state and the citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, between a state or citizens thereof and foreign states, citizens or subjects. This is basically proclaiming their actual power within that. This is on section 2 of the first paragraph. This is basically proclaiming their actual power of what they have jurisdiction over. Essentially, it proclaims pretty much in law and equity, pretty much over anything that covers the actual United States, including when it involves foreign states as well. And that would mean that basically that they must take, essentially, if there's cases brought forth, they must take a judgment thereof. And as we know what their actual basis for the judgments, we should know that their judgment should be taking place based on what we know of the actual Constitution. This means the actual amendments that we did before for the Bill of Rights. It also includes the amendments 11 to, I believe, 27, as well as the actual Articles 1 and 2 plus 4 through 7, and then obviously 3 as well to include themselves. And this is where we get to what ends up happening. And in many cases, what they're doing is they're not using their power wisely, and they need to understand that it governs over all of these cases, and they can't look the other way. And they should understand that there should be a very, very strict ruling on all of these points. And if we understood on the idea of the Ninth Amendment that there is no room for a living document interpretation, there would only be original intention interpretation for that point. And then when we view that, we should have the idea that essentially this is merely a rule book, not necessarily limitation on the rights. So essentially any idea of enhanced government powers and abilities should continually be struck down by the Supreme Court. or any other judicial court among the land. So anytime any type of group of any type of branch of government tries to overreach its bounds, it should be struck down. And the judicial branch itself should not be engaging in legislation, nor should it be engaging in the act of making any deference to either the legislative nor the executive branches. It should not be ignoring any of these. It should be exerting its power rightfully, which means basically it should be using the founding documents, the Declaration of Independence, as the basis and for the historical basis for a lot of it, and the essentially some of the fundamental ideas of rights, and then taking the Constitution as the essential rule book and using that to essentially assert its actual authority over how to judge these cases. And if they would have done so throughout history, there'd be a lot of different things, and essentially there'd be a severely limited application over the way we would create treaties and the way we would judge law. Essentially, we would probably not even have any civilian intelligence, because they would view them as a violation of the actual creation of any of them as a violation of the Fourth Amendment, because of the way they've reacted. They would say, if they would have noted that that the function of the creation of any of these things to actually make a solution, they would have actually recommended that any solution would have been to eliminate any agencies, not to create more, to eliminate the concerns on Fourth Amendment protections, such as when the FBI was getting out of initially when the CIA was getting out of whack. The solution should not have been to create such a thing as the FBI. And when the FBI was getting out of whack, it should not have been to create the NSA. The whole position should have been to eliminate the civilian intelligence. And this is a very simple idea. And when they did this, and they should have not essentially gave executive deference or even legislative deference in these cases. And they use it as ideas of precedent. And precedent doesn't matter, because we look at precedent on the idea of slavery. We can see that would not have been viewed as constitutional when you actually view black people as essentially as human beings. When you treat them as when you view them as human beings, you realize that they actually contain actual legitimate rights, and these are natural rights, which means that they must be free individuals to choose their actual path that they wish to choose. And this is why we don't go with. This is why judicial deference or judicial precedent is completely illegitimate. Now we go on to our next part, which is in all cases affecting ambassadors, other public ministers, and consuls, and those which a state shall be a party, the Supreme Court shall have original jurisdiction, and the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both to the law of fact and such exceptions under the such regulations as Congress shall make. That's basically what it's stating. That it's just stating in that case that it will be a level of hierarchy for the courts. It's pretty much what it's making there. It's saying in the case of these, in the case of when you appoint the ambassadors and such, it's going to have original jurisdiction because we're talking that's a federal case and it's going from federal to federal. But in the case of all other cases, you will file a level of hierarchy, and that's where we see how these cases run up, because we want to make sure that the cases are going, if they can be settled at a much lower level, let them be settled at a lower level if they can be resolved at those points. There's no point in letting every case start at a Supreme Court and essentially overrunning the Supreme Court with, essentially now we have 50 states. We initially did not. But now since we have 15 states, we are at a case to where we have we are at a situation to where it would overwhelm the actual Supreme Court if every case came about. And especially if we're talking over 330 million people, even if basically every 1,000 people filed the case, which is actually most likely pretty low, we're talking that in that case, you're saying that it would basically be well over several thousand. You basically seen, like, in that case we'd be talking like multiple thousands of cases every day that would have to be heard. It would have to be decided in each day, and that's not plausible for a Supreme Court. And you probably would have to have multiple levels of multiple numbers of judges, and you'd have to have multiple essentially groups of judges do this, and you couldn't have essentially the whole panel do it, or you'd have to have one judge hear the case and bring up the actual evidence to everyone else and explain what the oral arguments were, or had the oral arguments taped to bring up each thing, and each one would basically hear about 300 cases a day, and the case would have to be limited in time, because the fact is it would not be plausible. And this is why what we do, we keep these things down to let them be named at their each lower jurisdiction, let it work up, and only certain cases are going to be heard by the Supreme Court, so the Supreme Court doesn't have to hear every single case in the land. And then the third one, trials of all crimes except in case of impeachment shall be by jury. Such a trial shall be held in the state where the crime shall have been committed, but when not committed in any state, trials shall be at such a place as the Congress may by law have directed. Basically just stating, except in cases of impeachment, basically you have the trial by jury. In cases of impeachment, obviously it's going to be a trial by the actual congressional members themselves, which essentially is a trial by a jury technically. It's just a slightly different type of trial in itself, because you have the actual members that are actually trying them are actually the ones voting as well, which is a slight different formation than you would have for a traditional trial. In the case of, though, in the other cases, you will have the prosecution, the defense, and an actual judge and the jury. In the case of impeachment, you're going to have the Supreme Court judge, along with the person being charged, being the who's ever up for impeachment and removal of office, and then the members of whichever house it may be for whichever part of the trial it is, and that will be the case in which those are the ones that are going to be both doing the questioning and the voting. To actually prove the case. And then when we get, but in other cases, it will be trial by jury, and if there is no actual in the location, if there's not the actual location, not a real location for which it was really committed, then Congress, by law, directs where it will be, where the trial happens and where any punishment would happen. Because the punishment would happen within the same location as well. Within that case. This is like when we're talking about federal crimes. This isn't the case when we're talking about federal crimes. Like in the case like Timothy McVeigh with the Oklahoma City bombing, because it was, even though it was technically in Oklahoma City, it was because it was a federal building, it gets put under a different situation. And even though there are still many questions to this day about that, it's still the way in this instance, the way Congress orders it is he gets tried in as a federal jurisdiction, and then was executed on the federal jurisdiction as well. Though since when it came down to it, is a lot of that was dealt with the Assistant Attorney General, Eric Holder at the time. I think there's still a lot of questions that need to be answered about that whole case, because a lot of the whole outcome was kept secret, and nothing was allowed to be taped. And since that has existed, there's still been a lot of questions to this date. But that's really a complete other issue than what we're talking about here with the actual judicial powers themselves. But when you look at the judicial powers, I think they need to start actually looking at the Constitution as it was actually written, and instead of trying to say, well, we'll let the executive do this, and we'll let the executive do that, we'll let Congress do this. Oh, but Congress didn't really write this like they really meant to write this. They really meant to write it this way, so it would actually be constitutional, and we'll fix this for them. And, well, they really meant to start this in the House of Representatives, so we'll let them slide on that. And no, what's happening is we're seeing in a judicial that's letting things slide that shouldn't. They should be a lot more assertive with their power and say, well, you did this wrong, and guess what? This is completely wrong, and if you don't fix this, this is not going to pass, and we're not going to let this through. And they need to be a lot more assertive. They should do this on every single bill. Every single bill passed with it should basically, the Supreme Court should be grabbing, saying, is this constitutional? Is this constitutional? Is this constitutional? Is this constitutional? And they should be grabbing each one. Such as when we saw those anti-BDS legislation going through. Such as in the states, when the states were trying to do this. The Supreme Court should be grabbing every one of those things up and saying, this is not constitutional, it's not consistent with the First Amendment, we're throwing these out. We don't care what you state with it. This is an actual, they have the right to the freedom of speech. It supersedes whatever you want to state. Guess what? We're throwing these bills out. They're not constitutional. It doesn't matter on the 10th Amendment. The 10th Amendment does not supersede the rights of the people, because of the First Amendment being superior to the state's rights, because you had the right to freedom of speech. And that's where we're not seeing this being done by the actual Supreme Court. They're flat out ignoring it. When we look at some of the ideas of what the what's happening in FISA courts, well, the fact is those are not even constitutional. They're completely violating the Fourth Amendment. They're not even delivering out individual warrants. And to me, with it, everything coming into those FISA courts should be rejected. When we're talking about that, those are not constitutional warrants. You have to do an individual warrant stating the exact person, place, and things to be seized. And if you cannot give those are not constitutional warrants. The moment you can't do that, and those warrants should be rejected. That's why the FISA court system is completely illegitimate. Now, it's meant to actually curtail the actual abuses of the NSA, but as we see, it basically just gives them a rubber stamp. And when there's over 99% approval rating on it, we see what happens. And it's because we're talking that they're essentially getting the same thing as what would happen on a grand jury. Now, a grand jury is, as they say, you can indict a ham sandwich with a grand jury. And the same thing is happening with the FISA courts. When you don't have a defense there, it's easy to basically state your case, because when you only have the judge there and the prosecution there, there's nothing to counteract any of these statements, and they're not likely to look, when it's a secret court, they're not likely to look at the constitutional arguments, because you don't have to. And there's not going to be any repercussions from it. What needs to be understood is that this is not constitutional, and these people and these courts need to be shut down, because they're not anywhere close to being constitutional. They're just getting these pro-state lawyers or pro-state judges, I should say, and they're not even looking at the rights of the way you have to look at the Constitution. They're throwing the Constitution right out the door. And I'm probably going to go with later on today, I'm going to go with a argument on the NSA and other civilian intelligence, why it should be shut down, and why the expiration of Section 215 really does not matter, because the fact is they're going to find another backdoor way around it, and why they felt that they probably are not using it because they feel it to be onerous to do blanket spying, because it makes them actually have to fill out more paperwork. They just want to do blanket spying without the actual hassle. The more hassle, the less likely they are to use it, because they just want essentially general spying without that point. So that's why the Section 215 program was shut down virtually about 6 months ago, and they didn't want people knowing about it because they wanted people to think it was still active. And the reason why it was virtually shut down was because of the point that it was not considered to be valid, because there was too much paperwork. They had to file all this paperwork to get these stuff and show that they were looking for a specific person or a specific group of people. Well, that was too much work. Thus, all the data from this is going to be shut down when this program sunlights. But what we can probably expect is there's probably other programs that they're going under, such as a executive order, which is unconstitutional, which says the government for needs of national security can spy on the people for any such reason. This was an executive order from 1981 under Reagan, which is basically completely unconstitutional and a violation of the Fourth Amendment. And it totally negates the idea of that. And when we look at what the purpose of executive orders they are actually to define law. Well, when we look at it, that's not defining law. That's actually violating the Constitution. And if we had a judicial branch that was actually asserting its rights, they would have said this executive order back in 1981. And if you look at the Supreme Court back in 1981, you will see that it's Chief Justice was Warren Burger, who was the Chief Justice, who should have basically blocked it. William Brennan, Byron White's Thurgood Marshall, Harry Blackmun, Louis Franklin Powell Jr., William Rehnquist, J.P. Stevens, and Sandra Day O'Connor, and all of which should have actually blocked it. I mean, they should have easily blocked that from that point, and it doesn't take a genius to realize that. And this is something that's, when we're talking about these judicial powers, we're talking that this is what they're supposed to do. When we talk about their actual job, their job is to protect the Constitution. It's not to say, well, we're just going to let this go by, and we're going to give them executive deference or judicial, or we're going to give him legislative deference and say we're just going to like the ACA, we're going to basically rewrite it so it becomes constitutional. Not their job. Their job is to basically say this is unconstitutional, and to tell them sorry, bud, but this is not the way things go. And then we see the last part in Section 3 is treason against the United States shall consist of only levying against war against levying shall consist of levying war against them or hearing to their enemies, giving aid and comfort. No person shall be convicted of treason until testimony of two witnesses, same overt act or confession in an open court. Congress shall have the power to declare punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attained. And that's their last thing, is basically to go over the idea of treason. And when it comes down to it, is basically we need to redefine on the is one could actually redefine on this idea of levying war against the United States is what about or adhering to their enemies or giving aid and comfort. Well, giving aid and comfort is actually kind of an interesting idea. We talked about that in an earlier in the earlier live stream today, because when we're talking about giving aid and comfort, that's something that's quite interesting, because giving aid and comfort is something that's is very, very interesting, because it's it should be understood that when it comes down to it, is that when we see nations that are actually supposed to be allies but acting against our foreign policy interests and trying to essentially lobby to have our own congressmen essentially go against their own oath that they're supposed to upkeep by essentially supporting legislation that would be against the First Amendment to support a nation that's support that other nation, that's essentially giving aid and comfort. Even though when we're talking about Israel, this essentially would essentially be an ally, but giving aid and comfort to someone who wants you to subvert your own constitution and to subvert your actual own oath that you were supposed to take, and go against the actual foreign policy agenda of your own country by essentially trying to essentially go and aid actual groups that are actually meant to attack the United States, such as when Israel's defense minister stated that he'd rather have ISIS than Iran. Now, when they state that, that's essentially something that would be making someone an enemy and not an ally. And even though we can verbally claim that someone's an ally, but it does not make them so, because once they do that, essentially you have verbally made an attack on one's foreign policy. Now, when we start to look at that, we must look at some certain ideas, such as in the points of eras such as going through the world wars, when we had initially where we saw this an alliance between Russia and Germany, and that would be I think we're talking World War II. Sorry for being so stupid with this, but and then then we're talking the and that then you're talking that after that point is after that point we're talking that it started to once they essentially broke and attacked, you're talking that that alliance essentially broke apart. Well, when you start breaking someone's foreign policy goals and start trying to go against them when you're supposed to be an ally, it doesn't matter if you're directly attacking the person or the nation that you're supposed to be allied with, or essentially trying to defeat the foreign policy goals. You should essentially be at that point an enemy. Now, those who essentially give aid and comfort to this other country that's going against the foreign policy goals would essentially be this area for treason, when their idea is to hold this above their oath to the Constitution and willing to subvert the First Amendment. This technically would go down as treason, and I think this is something which we should have a serious discussion against. Now, obviously, it would be hard to get a couple of witnesses, or obviously in this case them confessing themselves, but it's an interesting discussion that we should have for people like Kevin McCarthy, who've actually done this, as well as some of the Democrats that have actually received a lot of support, and which is happening with a lot of neocons and some of the Democrats that have actually received money from AIPAC. Not to state that there's people receiving money from CARE that have actually not done the same exact thing. Because as they're basically as the country of Israel and the country of Saudi Arabia have essentially the same goals when it comes to foreign policy, which are completely opposed to that of what the actual necessary goals are for the United States. But these are essentially, but we need to claim these as essentially going against your actual oath you are meant to uphold, which is the actual Constitution. And this is something when we're talking about the goal of and role of the Supreme Court, of the courts, is to look into this. Now, while it might be hard to get two witnesses onto this, it will be it's at least an interesting discussion to have, as I've stated before. Now, if you like this idea on this discussion, like, subscribe, click the notification bell, and I will make sure to share it around social media. And I will see you guys later for a live stream. It'll probably be on the NSA and civilian intelligence later on tonight to discuss the different things going on with that. That'll be probably later on after this loads. Hopefully I can get it to load before I do my live stream tonight. Bye, everyone.